Hi guys, this is CA Balakrishna. Hope you all are doing well and your preparation is going well. From this video, we will be starting with revision lectures for corporate and economic laws, that is paper 4. Okay, I will be uploading revision lectures for all the chapters of paper 4. Okay, I will try to complete these revision lectures as early as possible. And also in paper 6D, we have started with a case study digest. I'll also try to complete even that case study digest series also before our May 2022 attempt. In this video, first of all, we'll start with revision of first chapter of corporate and economic laws, that is related to directors, appointment and qualification of directors. Basically, if you see in this chapter, the sections are from section number 149 to section number 171. Starting with section number 149. First of all, we'll see the basic structure of this section 149. We can divide this section 149 into two parts. First part would be basic provisions, which will be dealt by section number 141 to 149, subsection 1 to subsection 3. Those would be basic provisions, and remaining all sections till subsection 13 will be dealt by independent director. Okay, various qualifications and various provisions relating to independent director will be dealt by all the remaining sections of all the remaining subsections of section number 149. Now, if you see the basic provisions, subsection 1, subsection 2, subsection 3. Subsection 1 deals with again three concepts. The first concept is the director of a company must be individual. Okay, this is the basic point. After that, subsection 1 also deals with minimum and maximum number of directors that the company must appoint. If you see, the minimum number of directors that a company must appoint are, in case of a public company, there must be minimum 3 directors. In case of a private company, there must be minimum 2 directors. And in case of one person company, there must be minimum 1 director. These are the limits relating to minimum directors. Now coming to maximum directors. What is the maximum number of directors that the company can appoint? The Act has specified maximum limit of 15 directors. Okay. Now let's say company wants to appoint more than 15 directors, whether it can appoint or not. The answer is it can appoint more than 15 directors provided it passes general meeting special resolution. Okay, by passing general meeting special resolution, company can appoint more than 15 directors. Okay, and this provision relating to maximum of 15 directors is not applicable to government companies and section 8 companies. That means if a government company or section 8 company wants to appoint more than 15 directors, then it need not take approval of the shareholders. That is, a general meeting special resolution is not required in case of government company and section 8 company. Okay, the exception is only from maximum directors, not from the minimum directors. Okay, even government companies has to comply with the minimum director requirement. Okay, now the next question that arises is, okay, Act specifies some minimum limit of directors and maximum limit of directors. Now, whether articles of association of company can specify different limit of directors? The answer is yes. AOA can specify different limit of directors. Let us see. In case of minimum limit, okay, let's say the AOA specifies the minimum limit of directors. Then the limit that has been provided in AOA should not be less than the minimum limit that is provided by Act. Let's say, for example, in case of private limited company, Act specifies that minimum directors is 2. Now, AOA cannot specify minimum directors as 1. Okay, AOA can specify minimum directors as either 2 or more than 2. That is allowed. Okay, but AOA cannot specify minimum directors limit less than that specified by the Act. Hope that is clear. That is regarding minimum limit. Now moving to maximum limit. Whether AOA can specify maximum limit of directors? Yes, it can specify. once articles of association specifies maximum limit of directors, then the limit specified in the act will not have any relevance. Okay, let's say articles of association of company specifies that maximum directors is 7. In that case, the act limit of 15 will not have any relevance. Hope that is clear. And AOA can also specify maximum limit of directors 20 as well. Okay, more than the act can also be specified by AOA. Once AOA specifies maximum limit of directors, then act limit will have no relevance. In case of minimum directors, AOA can specify minimum directors of more than the act but not less than the act. That is regarding minimum and maximum number of directors and the limits specified by AOA. This would be the second topic that is dealt by section number 149 subsection 1. Now to the proviso to section number 149 subsection 1, there is a concept known as women director that we'll discuss. Okay, that we'll discuss later. Now section number 149 subsection 2 deals with transition provision. That means this limit of minimum and maximum number of directors must be complied by companies within a period of 1 year from the date of commencement of this act. Okay, this section is now having no relevance because this act has already commenced in section 2014 and 1 year has already elapsed, thereby this provision will not be having any relevance. Okay, now we'll see women director concept. Women director, see, basically to which types of companies this concept of women director is applicable. First of all, why a women director has to be appointed on the board? Basically to introduce concept of diversity in decision making of board of directors. The concept of women director has been introduced, and also to encourage women participation in the corporate world, this concept of women director is introduced, but this is applicable only to some types of companies. Applicability, it is applicable to every listed company. Okay, and other public companies having paid up share capital of 100 crores or more, turnover of 300 crores or more. Okay, that means for a private company this concept of women director is not applicable. Okay, for listed companies and unlisted public companies having paid up share capital of 100 crores or more or turnover of 300 crores or more must appoint how many women directors? At least one woman director. Okay, at least one woman director. Okay, now let's say there is a vacancy in the office of this woman director, then who will fill this vacancy? Board of directors will fill this vacancy. Okay, within which time they have to fill the vacancy? They have to fill the vacancy immediately in the next board meeting or 3 months from the date of vacation of office of women director, whichever is later, not earlier. Okay, whichever is later. Okay, later of these 2 dates the board of directors has to fill the vacation caused due to vacancy of women director. Okay, by this we will be completing section number 149 subsection 1, section number 149 subsection 2, which is a transitional provision. We are left with section number 149 subsection 3, which will be dealing with resident director. Now to which companies this concept of resident director is applicable? It is applicable to all the companies. Okay, it is applicable to private company, public company, listed company, to all the types of companies this concept of resident director is applicable. Okay, now how many resident directors should a company have? Company must have at least one resident director. Okay, who will be known as a resident director? A director will be known as resident director if he resides in India during current financial year for a period of more than 182 days. Okay, it is not a preceding financial year. You have to remember this. It is current financial year. You have to calculate 182 days of residence during current financial year. Okay, now let's say the company was newly incorporated company, or company was incorporated in the middle of the year. Basically company is not in existence for entire 365 days. In that case while calculating 182 days for resident director, you have to calculate proportionately. How? See, I have given an example. See, if company is in existence for 365 days, then the number of days for which the resident director must stay in India is 182 days. Now let's say, for example, company was in existence for 90 days only. In that case, what is the minimum number of days for which resident director must have stayed in India? You can calculate like this: 90 by 365 into 182, the cross multiplication, which would result into 45 days. Okay, if company is in existence for less than 1 year, then you have to proportionately calculate this period. Okay, by this we have completed basic provisions under section number 149 till section number 149 subsection 3, and the balance provisions of section 149 will deal with independent director. That will cover at the end of the revision end of this video. The concepts relating to independent director will discuss at the last. Okay, now moving to section number 152. Section number 152 deals with appointment, retirement and deemed reappointment of directors. You can divide this section number 152 into 3 portions. Section number 152 to 152 subsection 1 to subsection 5 deals with appointment of directors. Section number 152 subsection 6 deals with retirement of director by rotational concept. We'll discuss this concept of rotation. Okay. Section number 152 subsection 7 deals with deemed reappointment of directors. Okay. First of all, we'll see with subsection 1 to subsection 5, that is appointment of directors. The appointment of directors can be first of all divided into 2 parts. Appointment of first director, that means company is just incorporated and you want to appoint the first directors of the company. Then how you can appoint? This is the order of preference in case of appointment of first directors. First of all, you have to see whether articles of association of company provides any name of director. Okay, if articles of association provides any name, that person has to be appointed as a director, the first director of the company. Okay, let's say the articles does not provide any name, but articles provide the procedure through which you have to appoint the first director, that is processing AOA. If there is any procedure prescribed in articles of association, then you follow that procedure. Let's say articles of association has not provided name, has not provided any procedure. In that case, there will be subscribers to memorandum of association. Okay, there will be mandatorily subscribers to memorandum of association. Those subscribers to MOA will act as first directors of company. Okay, now what will be the tenure of these first directors? Their tenure will be till conclusion of first annual general meeting. In the first annual general meeting, shareholders will appoint the directors. Okay, till that time, till the first annual general meeting, these first directors will hold the office. That is relating to appointment of first directors of company. Next, appointment of subsequent directors. See, first of all, who will appoint the directors? Shareholders through general meeting ordinary resolution will appoint the directors. Okay, in annual general meeting they'll appoint the subsequent directors. Note, if act provides other procedure, follow that other procedure. Example would be for alternate director, for additional director and for nominee director, there is different procedure prescribed in section number 161. Their board of directors will appoint alternate director, additional director. For those directors, since act has provided different procedure under section 161, you follow that procedure. And for all the remaining directors, you follow this, that is general meeting ordinary resolution by shareholders for all the subsequent directors. This is regarding appointment of directors. Now, apart from this general meeting ordinary resolution, the person whom you have proposed as a director must comply with some other requirements. What are the additional requirements? First thing is, he must possess a DIN, that is director identification number. It is mandatory for a person to be appointed as director of a company, and he has to furnish this DIN to the company in which he is being appointed as a director. After that, he has to give a declaration that he is not disqualified under section 164. Okay, under section 164 there are various disqualifications. If director is attached with any of those disqualification, then he cannot be appointed as a director. Now, before he is being appointed as a director, he should give a declaration to the company stating that he is not disqualified under section 164. Okay. Next, consent. He should give his consent that he is accepting to act as director of this company. Once such consent is given, company must within 30 days of giving of such consent file with ROC a form known as DIR 12. Okay. Next, in case you are appointing any independent director, then in that case you have to give explanatory statement and a board statement. The board statement saying that in the opinion of board, this person whom we have recommended as independent director complies with all the provisions of section number 149, and explanatory statement why you are appointing this person as independent director must be provided as an attachment to the notice. Okay, these are some additional requirements regarding appointment of directors. Okay, by this we have completed section number 152, subsection 1 to subsection 5. Now we are left with two subsections of section 152, that is subsection 6 and subsection 7. See, section number 152, subsection 6, retirement by rotation. See, under subsection 1 to subsection 5, you have appointed the directors. Now, of those directors, some directors will be retiring directors by rotation. Those provisions will be dealt here. Let us see. First of all, to which companies this concept of rotation will be applicable? It will be applicable only to public companies and their subsidiaries as well. Okay. First of all, this concept of rotational directors will not be applicable to private companies. It will be applicable only to public companies. And also, if there is any private company which is a subsidiary of public company, in that case, for this private company, since it is a subsidiary of public company, the provisions of rotational directors will be applicable for this private company as well. Hope that is clear. Now, how many directors must be rotational directors? Before discussing this, first of all, we should understand that there will be two different concepts. One is rotational directors and another one is retiring directors. These two terms are different from each other. Okay. See, rotational directors means the directors whose period of office will be determined by concept of rotation. They will be known as rotational directors. Okay. Retiring director means of these rotational directors, directors who are going to retire in the annual general meeting would be known as retiring directors. Okay, that is the difference between rotational directors and retiring directors. Okay, now how many rotational directors the company must appoint? Not less than 2/3 of total directors. Okay, of total directors that are there in the company, not less than 2/3 must be rotational directors. Okay, of these rotational directors, how many should retire? 1/3 of rotational directors must retire at every annual general meeting. Okay. Now, whether AOA can provide that all the directors of company must be rotational directors only, all the directors of company must be retiring directors. Okay. Yes, AOA can provide. AOA can provide all directors to be rotational directors. If articles of association of company provides that all the directors of this company will be rotational directors, in that case, this provision will become irrelevant. Okay. In the same way, articles of association of company can also provide that all the directors of company will be retiring directors as well. Hope that is clear. Now, while calculating this concept of 2/3, you have to always round up. Okay, let's say you get any decimals, like if you calculated 2/3, you received some 3.2, you have to round up it to 4. You have received 3.8, you have round up it to 4, because here he used the terminology not less than. Okay, whereas in case of calculating 1/3 of rotational directors, you have to round off to the nearest value. If you receive 3.2, in that case you round off it to 3. you received 3.8, you round off it to 4. Hope that is clear. For calculating 1/3, round off to nearest value. For calculating 2/3, you have to always upward rounding has to be done. Okay. Now, okay, it is clear that of total directors, 2/3 must be rotational. Of these 2/3, 1/3 must be retiring directors. Now, when will they retire? At every annual general meeting, they will retire. Okay. Who will retire? See, director who is longest in the office will retire. We'll discuss this concept with an example. First of all, I'll just discuss this with you. After that, I'll also discuss with an example. This concept will be discussed in the form of example also. The director who is longest in the office will have to retire first. Let's say 2 or more directors are appointed at the same time. In that case, 2 options are available. Directors, by way of mutual agreement among themselves, anyone can retire. Or if say by this mutual agreement, directors are not able to decide who have to retire. Okay, no one is coming forward to retire. In that case, by draw of lots. These are the options through which a director who has to retire will be decided. Okay. Now, we'll see the concept of this rotational directors with an example. Let's say of total directors, we have taken 2/3 who have to be rotational director. If we have calculated 2/3, we received a number as 6. One second. We received number that 6. That means 6th. One second, I'll just close this and open again. Yeah, if we calculated 2/3 of total directors, we received the number as 6. That means at least 6 must be rotational directors. Okay, that means let's say Mr. A, Mr. B, Mr. C, Mr. D, Mr. E and Mr. F. These are rotational directors. Okay, that means their period of office will be determined by rotation. Now, of these 6 directors, in the next AGM, 1/3 must retire. 1/3 means it would be 2. 2 directors have to retire. Now, let's say this Mr. A was appointed first. After that, Mr. B is appointed, and Mr. C and Mr. D are appointed together. After that, Mr. E was appointed. After that, Mr. F was appointed. This is order of their appointment. Okay, first of all, Mr. A was appointed. After appointing Mr. A, after some days, Mr. B was appointed. Like this is the order of their appointment. Now, in the AGM, 2 directors from these 6 directors have to retire. Who will retire? Director who is longest in the office will retire. If you see here, Mr. A and Mr. B will be the directors who are longest in the office. Thereby, they will retire. Okay, they will retire. Now, the remaining directors that are left in the board are C, D, E, F. Okay, the positions of Mr. A and Mr. B has been vacated. Now, in these 2 positions, shareholders can either appoint same directors. That means shareholders can reappoint Mr. A and Mr. B, or appoint some other person in place of Mr. A and Mr. B by following section number 160. That is, right of a director, right of a person other than the retiring director to be appointed as a director. We will be discussing that section. By following section 160, the shareholders can appoint a person other than retiring directors as well. Okay, now let's say, or if they want, they can keep these positions as a vacancy. Okay, of these 3 options, any of the option can be selected by the shareholders. Now let's say shareholders have reappointed Mr. A and Mr. B. That means they will be freshly again reappointed. Now Mr. A and Mr. B are latest appointed directors. Okay. In the next AGM, let's say here these three directors are appointed together. C, D and F also appointed together. Okay. Sorry, not F, E is also appointed together. After appointing E, F was appointed in the fourth place. Okay. Now in the next AGM, again two directors have to retire. Now who will retire? The directors who is longest in the office will retire. If you see, Mr. C, Mr. D, Mr. E, these three people are appointed at the same time. That means these three people are longest in the office. Now from these three people, you have to select two directors who will be retiring. For selecting such two directors, you are having two options. First one is, you can ask Mr. C, Mr. D, Mr. D and Mr. E to discuss among themselves, and two directors from these three directors should come out as retiring directors. You can ask the three directors to do so. If these three directors are unwilling to retire, okay, no one wants to retire, no one wants to come out, in that case you have to draw the lots and you have to select names of two directors who will be retiring. Let's say after drawing the lots, C and E are retiring director. It was decided that C and E will be retiring through draw of lots. In that case, the remaining directors would be D. D will be left, and after that E is retired, C is retired, F will be left, and the latest recently appointed Mr. A, Mr. B will be there. One second. Mr. A, Mr. B will be there. Now there are two positions are vacant. That is, position of Mr. C and Mr. E is vacant. Now the shareholders doesn't want to reappoint Mr. C and Mr. E. In that case, they can appoint some other person. Let's say they have appointed Mr. X and Mr. Y. These are the latest appointed directors again. Okay. In the again next coming board meeting, general meeting, again some other two people have to retire. Now obviously the balance D and F will be retiring. Okay. And we will be left with Mr. A, Mr. B, Mr. X, Mr. Y. And let's say of this balance D and F have retired now, the shareholders have again reappointed this D and F only, and they will be reappointed. D and F are reappointed. That means in a period of 3 years we will be having entirely fresh faces in the board of directors. Okay. This is the concept of rotational directors. Hope this is clear. Next, who will retire and the vacancy. How the vacancy will be filled? If the director has retired, means some vacancy will be created in his office now. Now how the vacancy will be filled? It will be filled through general meeting ordinary resolution. Either these three decisions can be taken. First one is either reappoint retiring directors or appoint some other person as per section 160. Okay. Or keep vacancy as it is. Okay. Even keeping vacancy as it is also a decision. Okay. To decide this also, a general meeting ordinary resolution has to be passed. Hope that is clear, because it is also a type of decision that we want to keep these positions vacant only. For this also general meeting ordinary resolution is has to be passed. Now let's say in the general meeting none of the above action has been taken. Okay. The shareholders have not reappointed the retiring directors, or not have appointed some other person in the place of retiring directors, or not decided to keep the vacancy as it is. In that case, the general meeting will be adjourned to same day, next week, same time, same place, other than holiday. Okay. In the adjourned meeting also, no decision was taken. Okay. At the adjourned meeting also, no action was taken. In that case, the retiring directors are there na, they will be reappointed. Hope that is clear. That would be known as deemed reappointment, which will be dealt by section number 152 subsection 7. Okay, this is the concept of section number 152 subsection 7, which deals with deemed reappointment. Now, okay, before going into this, I have forgot to discuss one point here. We have seen that rotational directors would be 2/3 of total directors. Now, while calculating total directors, you should exclude some directors. Who are they? See, exclusions from total directors. See, independent director. Okay, for calculating rotational directors, you should not include independent directors. Okay, the basic purpose of appointing independent director is to keep them independent of any other director in the company. And you are, asking that independent director to retire. How is it possible? So, independent director will always be non-rotational directors. Thereby, for calculating 2/3, you have to exclude independent director from total number of directors. Okay. Second, SSD, that is small shareholder director. Even small shareholder director is also a independent director. We will be seeing that in section number 151. Thereby, since SSD is also a type of independent director, you should not include SSD in the total number of directors for calculating 2/3. Next, nominee director. Section number 161 subsection 3. Nominee director is a director who is appointed on behalf of some external institution. Okay. You cannot ask such a nominee director who has been appointed on behalf of external institute to retire. Thereby, even nominee director will also be non-rotational director. Additional director. The office of this additional director will be ending in the next annual general meeting. Okay, in the next annual general meeting, however he is going to retire, okay, however his office is going to complete in the next annual general meeting, then why again to keep this additional director in rotational director? Thereby, even additional director is also a non-rotational director, since he is however going to retire in the next annual general meeting. Okay. Next, proportional representation director. Directors who have been appointed through the concept of this proportional representation director is also a non-rotational director. Hope that is clear. These are the 5 directors which have to be excluded while calculating 2/3 of total number of directors. Okay. We have completed section number 152 subsection 6. In subsection 7, we have seen that if in the adjourned general meeting also no decision is taken, then the retiring director will be automatically reappointed. Now, in these 4 cases, automatic reappointment will not take place. What are these 4 cases? First one, retiring director gives unwilling notice. The retiring director gives a notice to the company that I don't want to be appointed as director in your company. In that case, you cannot reappoint this type of director automatically, because he said that he don't want to be appointed. Then how can you again reappoint this retiring director automatically? Therefore, the director who has given his notice of unwillingness to the company cannot be automatically deemed to be reappointed. Okay. Next, director disqualified under section 164. If a director is disqualified under section 164, he cannot be deemed to be reappointed. Okay. Next, resolution for his reappointment was lost. See, first of all, director was retired under section 152 subsection 6. After retiring, the directors, the board of directors have placed a resolution to reappoint these retiring directors, and this resolution was not approved by the general meeting shareholders. In that case, you cannot automatically reappoint this retiring director whose appointment was lost in the general meeting. Hope that is clear. Next, section 162 is applicable to the quiz. This is very important. First of all, we will discuss the concept of section 162. After that, we will link section 162 to this 152 subsection 7. First of all, what is section number 162? Appointment of directors to be voted individually. That means, let's say a company wanted to appoint Mr. A and Mr. B as directors of company. Now, as per section 162, for appointing Mr. A, you have to pass separate resolution, and for appointing Mr. B, you have to pass separate resolution. You cannot appoint these both directors together in the same resolution. Why? Let's say Mr. A is there, na? He is very bad person. Shareholders doesn't like Mr. A, but board of directors like Mr. A. Board of directors know that if proposal to appoint Mr. A was placed before the shareholders, shareholders will right away reject the appointment of Mr. A. But Mr. B is very good person. Okay, shareholders wanted to appoint Mr. B as a director of company. Thereby, what this board of directors will do now, they will place a resolution before the shareholders wherein the appointment of Mr. A and Mr. B is proposed in the same resolution. That means the shareholders are having option either to reject both the directors or to appoint both the directors. They are not having option to reject Mr. A and appoint Mr. B, because their both appointments are proposed in the same resolution by board of directors. So to prevent these types of mismanagements and these types of unfair practices in the company, the concept of section 162 is introduced, wherein for appointing one director you have to mandatorily use only single resolution. Okay, two or more directors cannot be appointed through a single resolution. That is the concept of section number 162. 162. But there is an exception to that. What is the exception? See, now board of directors want to appoint Mr. A and Mr. B as directors of company through same resolution. Now what board of directors can do is, first of all, they have to ask the shareholders. What they have to ask? Shareholders, we want to appoint Mr. A and Mr. B as directors through same resolution. Whether all of you agree to this resolution or not. Okay. If all the shareholders unanimously agree that, okay directors, you appoint Mr. A and Mr. B through same resolution, we are not having any problem. Such unanimous approval should be given by shareholders to the board of directors. Once such unanimous resolution is given to the board of directors, now board of directors have got power to appoint, to recommend appointment of Mr. A and Mr. B as directors in the same resolution before shareholders. Okay, this is the exception. Hope that is clear. Now, however, this concept of section 162 is not applicable to government companies and private companies. That means a government company and a private company can appoint two or more directors through the same resolution. There would be no issue in case of government companies and private companies. Now we will be linking the concept of section number 162 with section number 152 subsection 7. Let us understand this with an example. See, let's say there is a particular director, Mr. A. Okay, he is appointed on particular date, and in the next AGM this director has to retire. Okay, this director has retired. Okay, Mr. A has retired. Now by concept of rotation under section 152 subsection 6, this Mr. A has retired in the AGM. Now after retiring, the place of vacancy created in the board of directors has to be refilled, or it has to be kept vacancy, or Mr. A can be reappointed to this position again. These three decisions are not taken in the general meeting, thereby the general meeting was adjourned. In the adjourned meeting also no decision was taken, thereby Mr. A is reappointed, deemed to be reappointed under section 152 subsection 7, deemed reappointment. This is the general situation. Now let's say we will apply section number 162 to to this situation. What section number 162 says? It says that two or more the directors cannot be appointed to through single resolution. Now in this case, while appointing Mr. A and Mr. B are appointed, one second, yeah, Mr. A and Mr. B are appointed through single resolution only. Now there is contravention of section number 162. Now again the same thing is repeated. There is contravention of section number 162. In the AGM, Mr. A has to retire by rotation. He has retired, and the general meeting was adjourned since no decision was taken. In the adjourned meeting also no decision was taken. In this case, Mr. A cannot be deemed to be reappointment. Why? Because the original appointment of Mr. A was in contravention of section 162. That is, original appointment is not valid. If original appointment is not valid, you cannot deem that retiring director to be reappointed under section 152 subsection 7. Hope that is clear. Okay. Now the question that arises is, appointment of Mr. A is invalid since section 162 has been contravened. Then what about the actions that this Mr. A has performed during the period? Whether all the actions will become invalid? No, actions will be valid as per section number 176. This section number 176 will be discussing in chapter number 3, that is meetings of boards and its powers. As per section number 176, if there is any defect in the appointment of the director, then all the actions that are performed by the directors will be valid only. Hope that is clear. This is reading together of section number 162, section number 152 subsection 7 and section number 176. Hope that is clear. Now we have completed 152 subsection 7, 162. Moving to section number 151, small shareholder director. First of all, to which companies this concept of small shareholder director is applicable? It is applicable only to listed companies, and also even in this listed companies also it is not mandatory, it is optional. If listed company wants, it can appoint small shareholder director, otherwise it can avoid appointing small shareholder director. It is completely optional. Okay. Now, who is a small shareholder? Any shareholder who is holding shares of nominal value of less than 20,000 rupees will be known as small shareholder. Here you have to remember that it is nominal value, not fair value or market value. Okay, the nominal value should be less than should not be more than 20,000 rupees. Then such type of shareholder will be known as small shareholder. Okay, now appointment of small shareholder director. There are two routes through which a small shareholder director can be appointed. First route is suo motu by listed company. Okay, listed company itself can feel that there should be a particular director on the board of directors who represents all the small shareholders. If listed company feels so, then it can suo motu appoint small shareholder director. Okay, or notice given by small shareholders. Okay, even though small shareholders gives notice, it is not mandatory on the listed company to appoint small shareholder director. After receiving the notice, if listed company wants, it can appoint, otherwise it can avoid appointing small shareholder director. Now how many small shareholders have to give the notice? 1000 small shareholders or 1/10 of total small shareholders, whichever is lower. Okay, the notice for appointment, that is for proposing the small shareholder director, has to be given by not less than 1000 small shareholders or 1/10 of the small shareholders. Within how many days the notice has to be given? The notice has to be given at least 14 days before the annual general meeting of the company, and the notice has to be left at the registered office of the company. Okay, what should be present in the notice? In the notice you have to mention the name, the candidature of the person whom you are going to propose as a small shareholder director. Okay, his name, his director identification number, his address, his consent, and if he is holding any shares, the number of shares being held by him. See, it is not mandatory that the small shareholder director must hold shares in the company. It is not mandatory. Even a person who is not holding any shares in the company can be appointed as small shareholder director. Hope that is clear. All these details must be given in the notice. Along with these details, the small shareholders who are proposing this person, the details of these small shareholders should also be given, and their signatures must be made in the notice. Okay, name, address, shares held, if any. Okay, here you can write if any. If such a person is holding shares, you mention the number of shares, otherwise it is not mandatory. Next, DIN, director identification number, consent, not disqualified. The person whom you are proposing to be appointed as small shareholder must not be disqualified under section 164. Okay, such a declaration that he is not disqualified should also be given along with this notice to the company, and comply with the requirements of independent director. I have already told you that this small shareholder director will be treated as an independent director. Thereby, this director has to comply with all the requirements of section number 149 subsection 4 to subsection 13. Those provisions will be discussing. Okay, the small shareholder director should comply with all those provisions. Okay, some additional points. What would be the tenure of small shareholder director? It would be 3 years. After 3 years, you cannot reappoint the small shareholder director. For how many years you cannot reappoint? For a period of again 3 years. That means cooling period is also 3 years. Okay, and not liable to retire by rotation. We have already discussed under section 156 subsection 2. Small shareholder director will not be liable to retire by rotation. Okay, and how many small shareholder directorships can be held by particular person? Let's say there is Mr. A. How many SSDs, small shareholder directors, can be held by this Mr. A? He can hold maximum of 2 small shareholder directors. The two, let's say Mr. A is appointed as small shareholder director of A Limited. Now B Limited also wants to appoint Mr. A as small shareholder director. Whether he can be appointed or not? The answer is yes, he can be appointed, provided B Limited is not in the same business that A Limited is carrying on. Okay, subject to such condition, Mr. A can be appointed as small shareholder of B Limited also. Okay, Mr. A is appointed as small shareholder of A Limited, B Limited, and C Limited also wants to appoint Mr. A as small shareholder director. Whether C Limited can appoint or not? The answer is no, it cannot appoint. A person can be appointed as a small shareholder in maximum of 2 companies only. That too, the second company must not be in the same lines of business of the first company. Okay, that is regarding small shareholder director, section number 151. Moving to section number 161, which deals with appointment of various directors, that is alternate director, additional director, nominee director, and casual vacancy. There will be 4 subsections in this 161. Subsection 1, 161 subsection 1 deals with additional director. First of all, the concept of additional director will be applicable to all companies. Okay, which director will be known as additional director? See, let's say in the company the work burden has increased a lot. The existing directors are not able to carry on the this increased workload in the company. Thereby, what these existing directors can do is they can appoint additional director into the company to manage this additional work burden. Okay, that would be the idea of additional director. Now, who can appoint this additional director? Board of directors can appoint additional director. Okay, board of directors can appoint additional director. That means shareholders cannot appoint additional director. Okay, board of directors through board meeting ordinary resolution. Also, such power for appointing additional director to the board of directors must be given in the articles of association. Okay, if articles of association provides that board of directors is having power to appoint additional directors, only in that case board of directors can appoint additional director. If articles of association doesn't give the power, then the board of directors cannot appoint additional director, and a general meeting shareholders however cannot appoint additional director. Okay, the shareholders are not having power to appoint additional director, only board of directors are having power to appoint additional director. That too, the power is granted to board of directors by articles of association. Hope that is clear. Next, tenure. What would be the tenure of this additional director? The tenure would be till the conclusion of next annual general meeting. We have already discussed in section number 152 subsection 6, that is in calculating rotational director, that is 2/3 of total number of directors. From the total number of directors, we have to exclude additional director. Why we have excluded? Because his tenure is however going to be completed in the next annual general meeting. That is, thereby his tenure is till next annual general meeting. Okay. Now the question is whether rejected director can be appointed as additional director. That means there is particular person, Mr. A. The proposal to appoint Mr. A as director is placed before shareholders. Shareholders have rejected this proposal. Okay. That means the company cannot appoint Mr. A as director. Now what this board of directors have done is, Mr. A's appointment was rejected by shareholders. Thereby, board of directors want to appoint this rejected Mr. A as director through additional director. Okay, this would be known as backdoor appointment. Such backdoor appointment is not possible. Okay, any person who is rejected to be appointed as a director by shareholders cannot be appointed by board of directors as additional director. Hope that is clear. Next, person already director or additional director of the same company cannot be again appointed. Okay, Mr. A is already holding position as a director in A Limited. Now he cannot be again appointed as additional director in the A Limited. Hope that is clear. However, he can be appointed as additional director of B Limited. Okay, Mr. A is director in A Limited. Now A Limited cannot appoint A as additional director, but B Limited can appoint. Hope that is clear. That was section number 161 subsection 1. Moving to section number 161 subsection 2, which deals with the concept of alternate director. What is this alternate director? First of all, before discussing the alternate director concept, we will discuss the concept of vacancy. Okay, vacancy of director. The office of director can be vacated in two situations. First one is director is on leave. Okay, if director is on leave, the office will be in vacation, or accident, death, disqualification, etc. of director. Okay, the director who has been appointed to the position of directorship has died or met with accident or has been disqualified under section 164. In that case also, the office of this director will be vacated. That would be known as casual vacancy. Okay, if he is on leave, this is normal vacancy. See, in leave also, leave is for less than 3 months. In that case, no action is required. Okay, now the leave that has been taken by the director is more than or equal to 3 months but less than 12 months, and leave that has been taken is more than 12 months. Okay, director is in leave for more than 12 months. That means the office of director is in vacation for more than 12 months. In that case, such a type of vacation would be known as casual vacancy. Why? Because if the office of director is in vacation for more than 12 months means he has not attended at least one board meeting in the past 12 months. That type of interpretation we can take. If he has not attended at least one board meeting means under section 167 his office will become vacated, and that vacation would be known as casual vacancy. Hope that is clear. That is regarding casual vacancy. Now coming to this point where the director is on leave for more than 3 months but less than 12 months, and he is on leave for such period, but during that leave he is present in India only. In that case, no action is required. But during that leave he is outside India. That means he went outside India, he is abroad. In that case, board may appoint alternate director. Okay, it is not mandatory. Board may appoint alternate director. Alternate to whom? Alternate to director who is on leave for more than 3 months and who went outside India. Okay, who is abroad. On behalf of such director, an alternate director can be appointed by whom? By board of directors. Shareholders cannot appoint alternate director. Okay, and also the power to appoint this alternate director to board of directors must be given by articles of association. Okay, articles of association must give power to the board of directors to appoint alternate director, or power can also be given by general meeting ordinary resolution. Okay, this is the additional route through which power can be given to the board of directors for appointing alternate director. For appointing additional director, power cannot be given by general meeting ordinary resolution. Only for appointing alternate director, power can be given to board of directors by shareholders ordinary resolution or by AOA. Hope that is clear. This is one of the difference between section number 161 subsection 1 and subsection 2. Hope that is clear. Now again, another question that arises is, alternate director is being appointed on behalf of a director who is abroad. Now whether such director who is abroad can appoint alternate director on his behalf? No, even such director cannot appoint alternate director on his behalf. The power to appoint alternate director is only with the board of directors. Hope that is clear. Next, additional points regarding this alternate director. What would be the tenure of this alternate director? The tenure of the alternate director would be till the time the original director was appointed, or till the time the original director returns to India, whichever is earlier. Hope that is clear. Next, alternate director for independent director. Whether an alternate director for independent director can be appointed. Let's say the independent director is on leave for more than 3 months and he is abroad. Now against this type of independent director who is on abroad, whether an alternate director can be appointed? The answer is yes, alternate director can be appointed, provided such alternate director should also comply with all the requirements of section number 149 subsection 4 to subsection 13. Okay, all the requirements, all the qualifications of independent director must be complied with this alternate director also. Next, whether removed rejected director can be appointed as alternate director? Yes, removed rejected director can be appointed as alternate director. This is also one of the difference between section number 161 subsection 1 and section number 161 subsection 2. Next, section number 161 subsection 3, which deals with nominee director. Who is a nominee director? Basically, nominee director is a director who is appointed to the board of directors on behalf of some external organization. Let's say the company has taken some loan from a financial institution. Now such a financial institution can appoint a person as their nominee in the board of directors, or central government has invested into the company. Now the central government can appoint their nominee in the board of directors of company, and the same would be in case of state government. Such type of director would be known as nominee director. Now who is having the power to appoint nominee director? Obviously the power to appoint nominee director is with board of directors only. Okay, nominee director will be recommended by such external institution, but such external institution cannot pass resolutions in the company. Okay, at at final the board of directors are the one who has to pass the resolution in the company. Thereby the power to appoint the nominee director is with board of directors only. Okay, board of directors will appoint the person who is recommended by such external agency as the nominee director. Hope that is clear. And what is the tenure? The tenure would be till the time such external agency wants their representative in the board of directors. Hope that is clear. And also you have to remember that even this nominee director should also comply with all the basic requirements. That is, he should not be disqualified, he should possess DIN, and he should give consent. All these basic requirements for directors have to be complied even by this nominee director also. By this section number 161 subsection 3 is completed. Now casual vacancy, section number 161 subsection 4. First of all, to call a particular vacancy as a casual vacancy, there must be two conditions satisfied. What are they? First condition, original appointment must have taken place in the annual general meeting. Okay, the director who has vacated must have been appointed in the annual general meeting. Only in that case the vacancy of such director can be called as casual vacancy. That is the first condition. Second condition, office is vacated before the expiry of term. Okay, the director has been appointed for 5 years. Now the office is vacated in 3 years only, and such appointment was made in the annual general meeting. Only if these two conditions are satisfied, such vacancy can be known as casual vacancy. Hope that is clear. Now, if at all any casual vacancy is created in the board of directors of the company, then who can fill this casual vacancy? The power to fill the casual vacancy is with board of directors through board meeting ordinary resolution, and subsequently such appointment must be approved by the shareholders through general meeting ordinary resolution. Hope that is clear. Next, tenure. What would be the tenure? Tenure would be till the expiry of term of original director. See, first of all, Mr. A. Mr. A was appointed for 5 years. After 3 years, there was some casual vacancy in the office of Mr. A, and in place of Mr. A, Mr. B is appointed to fill this casual vacancy. Now, the tenure of this Mr. B would be for 2 years. That is balance period which is unserved by Mr. A. Hope that is clear. Now there is one particular issue here. See, let me tell you. Now there is Mr. A. Okay, let's say Mr. A is appointed for 5 years. Okay, now he is appointed in the AGM. Okay, now second I'll just what happened. There is a Mr. A who is appointed as a director. He has been appointed for 5 years. He has been appointed for 5 years in the annual general meeting. Now, after 3 years, Mr. A died. Okay, it resulted into casual vacancy. Now, this casual vacancy is filled by appointing Mr. B. Who appointed Mr. B? Board of directors appointed Mr. B. Now, after again 1 year, the term of Mr. B would be 2 years. Okay, the balance unserved period. Now, after 1 year, Mr. B also died. Now, tell me whether this vacancy can be called as casual vacancy. Okay, Mr. B also died. Whether this vacancy can be called as casual vacancy. Check the two conditions. The first condition is original director must be appointed in AGM. The original director is Mr. B here. You should not take Mr. A. Okay, Mr. B, the office of Mr. B is vacated. He is appointed not in the AGM. He is appointed by board of directors. Thereby, this vacancy cannot be called as casual vacancy. Hope that is clear. And this vacancy cannot be filled by board of directors. Okay, this vacancy must be filled by general meeting ordinary resolution only. Hope that is clear by following section number 160. Okay, this is one of the concept relating to casual vacancy. Next, filling of casual vacancy. I have given a small chart. See, there will be casual vacancy of women director or vacancy of independent director. Those vacancies must be filled not later than next board meeting or 3 months from the date of such vacancy, whichever is later. Okay, that time period is applicable for casual vacancy of women director, independent director. But casual vacancy of all other director, for casual vacancy of all other directors, there is no such urgency. Okay, there is no such time limit within which the vacancy has to be filled. Okay, hope that is clear. Next, moving to section number 160, that is right of a person other than a retiring director to be appointed as a director of company. Let's see. First of all, that means a person who is no way concerned with the company wants to be appointed as a director of the company. Whether he can be appointed or not, yes, he can be appointed by following section number 160. Now, under section 160, there are three options to appoint a person as a director. The first option is recommendation made by the existing directors. Okay, the existing directors of a company can recommend any person to be appointed as a director of the company. That is the first option. Or recommendation by the members, that is shareholders of a company, can recommend any person to be appointed as director of a company, or such person himself can approach the company, providing his candidature, submitting his candidature to the company, stating that I want to be appointed as director in your company. Okay, these are the three options available under section 160 to appoint a person other than retiring director as a director of the company. Now, in these two cases, that is recommendation made by the shareholders, approached by that person himself, in these two cases, what is the procedure? The candidature or proposal must be given to the company at its registered office at least 14 days before the annual general meeting. Okay, candidature will be given if the person himself approaches. Proposal will be made if the members are proposing. Okay, now along with this notice, along with the candidature or proposal, a deposit of 1 lakh must be given to the company. Okay, in case of Nidhi company, the deposit is 10,000 only. Okay, 1 lakh deposit is not applicable for Nidhi company. For all other companies, deposit would be 1 lakh. Next, once the company received the notice, that is the candidature or the proposal, and also 1 lakh rupees of deposit, now the action that the company has to perform is within 7 days. It has to forward within 7 days of what? Before 7 days of conducting of annual general meeting, it has to forward candidature to the members individually, either electronically or by post. Okay, and place his candidature and the proposal on the website of the company if the company is having website. Otherwise, it is not necessary. Next, no individual notices to members is required if the company advertises such candidature or proposal in at least one vernacular newspaper and at least one English newspaper. Okay, here you can write and. Next, non-applicability of section 160. This section number 160 is not applicable to government companies and its subsidiary. 1 second. Give me 1 second. Yeah. This section number 160 is not applicable to government companies and its subsidiaries, private companies and section 8 companies. And also remember that wherever I am saying that there is exception from applicability of particular section, the exception will be applicable only if such company has not defaulted in filing its annual return and filing its financial statement. That two conditions you can apply for all the exception points. Next, we left with this deposit point. We have said that company will accept a deposit of 1 lakh from such a proposed person. Whether this deposit will be returned to him or not. See, refund of deposit. You can divide it into two portions. First of all, the person is appointed as director. Okay, the person has been recommended by the shareholders or person himself approached, and you have collected 1 lakh rupees. And when the resolution was proposed, in the shareholders meeting, they have approved the resolution and have appointed such person as a director of the company. That means that person has become successful. If he is success, that is appointed as director, then this 1 lakh rupee refund, the 1 lakh rupee of deposit will be refunded to him. That is one case. He is not appointed as director. Okay, the resolution was not approved by the shareholders. In that case, you have to check whether the number of votes received in favor of his appointment are more than 25% of his total votes. Yes, total votes received are more than 25%. In that case, you have to refund the 1 lakh rupees. Or total votes received are less than or equal to 25%. In that case, you have to check another condition, whether your company is a Section 8 company. If your company is a Section 8 company, then director can decide whether to refund or not. Okay, at the discretion of the directors. If the company is a Section 8 company and the person has received less than or equal to 25% of voting rights, then the company at the discretion of the directors can either refund or forfeit the deposit. In case other companies other than Section 8 companies, then the company will forfeit the deposit of 1 lakh rupees. Okay, no refund will be given if he secures less than or equal to 25% of total voting rights or total voting. That is a concept relating to refund of deposit. Next, by that we have completed section number 160. Moving to section number 165, that is maximum directorships. That means how many directorships that a single person can hold. The answer is a person can be appointed as a director of maximum of 20 companies. Okay, 20 companies. The two, from this 20 companies, he can be appointed as a director of public companies of maximum 10 only. Okay, of this 20, the maximum number of public companies in which he can be appointed as a director is 10 only. Okay, and remaining will be other companies. Now, while calculating public companies, private companies which are subsidiaries of public companies should also be considered as public companies for the purpose of this limit of 10 public companies. Hope that is clear. Next, while calculating this 20 limit of 20 directorships, you have to exclude the directorships in dormant companies and Section 8 companies, and also you have to include alternate directorship as well. Okay, for calculating 20 directorships, exclude directorships of dormant company and Section 8 company, include alternate directorship as well. For what? For calculating maximum of 20 directorships. Now the answer is, the act says that as per section 165, the maximum number of directorships that a person can hold are maximum 20. Now, whether the company in its articles of association can specify a lesser number of maximum directorships. Yes, the answer is the company can its articles specify lesser number of directors. It is available to the company. Okay, if the company wants, it can specify that the persons who are acting as directors of our company can act maximum of directors of 15 companies only, maximum of directors of 10 companies only. Such a type of lesser limit can be prescribed in the articles of association of the company. For prescribing such a lesser limit, general meeting special resolution is required. Next, disqualification of director, that is section number 164. Basically, you can divide these disqualifications into two parts. The first disqualification, that is section number 164 subsection 1, deals with individual default disqualifications. 164 subsection 2 deals with company default disqualifications. That means in subsection 1, the director will be disqualified if these defaults are committed by director. Under section 164 subsection 2, director will be disqualified if these defaults are committed by company in which he is acting as a director. Hope that is clear. Now, subsection 1, section number 154 subsection 164 subsection 1, which deals with individual default disqualification. First disqualification is person is unsound mind. Okay, he cannot be appointed as director, he is disqualified. Or he is undischarged insolvent. Even if he is a undischarged insolvent, he cannot be appointed as director. Or he applied to be adjudged as insolvent and application is pending before the court. Even in that case also he cannot be appointed as director. Basically, these points of disqualifications are linked to section number 196 of the second chapter that we will be discussing in the next video. While discussing those points, I will link all these points with those points that are prescribed there. Okay. The name of that chapter is appointment and remuneration of managerial personnel. In that chapter I will be linking these points. Okay, that is the third type of disqualification. Fourth disqualification, convicted by court. Okay, the person is convicted by a court and the imprisonment, that is the punishment of imprisonment that is granted to him is less than 6 months. If the imprisonment is less than 6 months, then he will be qualified to be appointed as director. There will be no disqualification. If the imprisonment is more than 6 months but less than 7 years, in that case disqualified from being appointed as a director for a period of 5 years. 5 years from when? From expiry of sentence. Okay. If imprisonment is for more than 7 years, in that case he is lifetime disqualified from being appointed as director. Hope that is clear. Next, fifth disqualification is order of disqualification passed by the court or tribunal. The example would be under section 242, that is operational mismanagement. The tribunal can pass an order under section 242 disqualifying a particular director from being acting as a director if any complaint under section 241 is made against him for a purpose of operation or mismanagement. Okay, that would be one of the example where court can pass an order, court or tribunal can pass an order disqualifying the director. Next disqualification, the person has failed to pay the calls on the shares. Okay, he has subscribed shares of the company and he failed to pay the call money on the shares, and such default of non-payment of calls has continued for a period of 6 months. In that case he will be disqualified to be appointed as director. Or he has been convicted under section 188, that is related party transactions. Okay, he has been convicted for entering into related party transaction. Even in that case he cannot be appointed as a director, he will be disqualified. Next, the person is not having DIN. Having DIN is mandatory. If person is not having DIN, he cannot be appointed as director. And the last disqualification is exceeding the maximum directorships under section 165. In the previous section only we have discussed that the maximum number of directors that a person can hold is 20 directors. If such limit is exceeded, he cannot be appointed as director. These are the individual disqualifications, individual default disqualifications. Moving to company default disqualifications. If company performs or commits these two types of disqualifications, then the director will be disqualified. Now these two types of defaults, then the director will be disqualified. What are the defaults that will be committed by the company? The first default, company failed to file financial statements or annual returns for 3 continuous financial years, or failed to repay deposits, debentures, that is repay the deposits accepted, or redeem the debentures, or pay the interest accrued on deposits or debentures, or pay the declared dividend for a period of 1 year. Okay, such default has been continued for a period of 1 year. In that case, the persons who are acting as directors of such companies will be disqualified from reappointment in defaulting company. Okay, such a person cannot be reappointed in the defaulting company. He can continue his present appointment, but he cannot be reappointed in the defaulting company. And appointment in other companies, in the other companies he has to vacate. Okay, in the present company he can continue and cannot be reappointed. In other companies where he is holding the directorships, he has to vacate. Okay, for how many years? For a period of 5 years he will be disqualified. Hope that is clear. Now let's say newly appointed director. The company has already committed default. After committing defaults, after 3 months of committing default, a new director is appointed to this company. Once this new director is appointed to the company, he will not immediately attach with the disqualification. Okay, after a period of 6 months he will be attached with the disqualification. Hope that is clear. In case newly appointed director shall not incur disqualification for a period of 6 months. Note, private companies can provide for additional disqualifications. Okay, these are the disqualifications that are provided by act. Apart from these disqualifications, private company can provide for additional disqualifications in their AOA. Hope that is clear. That is section number 164, which deals with disqualification of directors. Now section number 167, which deals with vacation of office of directors. Most of the students will confuse between section number 164 and section number 167. See, section number 164, which deals with disqualification of directors, must be complied by the directors before his appointment as well as after his appointment. That means section 164 has to be complied before appointment, after appointment. Okay, while you are appointing, you have to check whether that person is complying with section 164 or not. After appointing also, he has to continuously comply with section 164. That is section 164. Section 167, okay, after appointing, this person must comply with section 167. Okay, if he incurs any of the disqualifications of section 167, he will vacate the office. Okay, section 164 is also one of the point of section 167. Okay, hope this is clear. Section 164 has to be checked on the date of appointment as well as after the appointment, whereas section 167 has to be checked after the person has been appointed as director. Hope that is clear. Because a director cannot vacate the office without being appointed. That is the reason why section 167 has to be checked after appointing the director. Now let's see. Vacation of office of director. What are the cases in which the director will vacate his office? First one is if he incurs disqualifications under section 164. Okay, these points which we have already discussed. If he incurs any disqualifications under this 164, the person will vacate the office under section 167. Okay, next, absence from all board meetings in past 12 months. This point I have already discussed. Okay, while discussing casual vacancy point, if he fails to attend at least one board meeting in the past 12 months, he will have to vacate his office as per section 167. Next, contravenes section number 184 or fails to disclose interest under section number 184. These are interested transactions. Okay, if a director enters into any contracts in which he is interested, he has to make some disclosures under section 184. If he fails to make disclosures, and there are also additional disclosures that the director has to make under section 184. If he fails to disclose the disclosures under section 184, he will have to vacate his office under section 167. Next, disqualification order by court or tribunal. This point we have already discussed in section number 164. Next, convicted of offense and imposed and imprisoned for 6 months or more. Even this point also we have discussed. Next, disqualified under section 217 subsection 6. This is 217 subsection 6 is in the chapter of inspection, inquiry and investigation, wherein all the directors and officers of the company has to comply with the directions given by the registrars and inspectors appointed by central government. If they fail to comply with the directions given by the registrar or directions given by the inspector, then they will be disqualified. Okay, they will have to vacate the office under section 167. Hope that is clear. Next ground on which the director has to vacate the office: appointed as director by virtue of him holding other office. Let's say, for example, president of ICAI. Okay, president of ICAI has been appointed as director of A Limited just because of the reason that he is president of ICAI. Okay, just because of the reason that he is president of ICAI, he has been appointed as office of as a director of the A Limited. Now, the president of ICAI will vacate his office after 1 year. After 1 year, again a new person will be appointed as president. Now the president will have to vacate the office from A Limited because he has been appointed as a director of A Limited because of him holding some other office. Okay, the new person who is appointed as president of ICAI will be replaced in this A Limited as director. Hope that is clear. Okay, appointed as director by virtue of him holding other office. Okay, he has been appointed as director of our company since he is holding that another some office. If he vacates such office, he has to vacate office of director of our company also. Hope that is clear. Next, the next question is, what happens if all the directors vacate? Okay, if all directors are disqualified and all directors are vacated, then who will manage the company? The answer is, if the company is having promoters, the promoters will be appointed as directors and they will manage the company. Or in their absence, central government will appoint directors and these directors will hold the office till directors are appointed by shareholders in the general meeting. Hope that is clear. That is section number 167, which deals with vacation of directors. Next, section number 168, resignation of directors. Whether directors can submit their resignation? The answer is yes. How? First of all, directors have to give their resignation notice to the company. Once the notice is given to the company, within 30 days, company must file DIR 12 with the ROC. Okay, and even director should also within 30 days of resignation file DIR 11 with the ROC. Hope that is clear. Now, effective date of resignation. What would be the effective date of resignation? From which date the director will be deemed to be resigned? It would be later of following the following 2 days. What are these 2 days? Date of receipt of notice by the company or date specified in the notice. See, the director sent his resignation notice. In the resignation notice, he specified that I will be resigning from 5th of March 2021. This is the date specified in the notice. Now, this notice reached the company on 8th March 2021. Now, effective date of resignation would be 8th March 2021. That is later of date specified in the notice or the notice received by the company. Hope that is clear. Now let's say, okay, let it be. Yeah, same. The director has in the notice specified that he will be resigning from 5th March 2021. Okay, he posted this notice to the company on some, let's say, some 15th of February 2021. Okay, on 15th of February 2021, he posted a notice in which it is mentioned that he will resign from 5th March 2021 to the company, and this notice is received by the company on 3rd March 2021. Now, the later of date mentioned in the notice or date of receipt of the notice would be 5th March 2021. Thereby, director will be retiring or resigning from 5th March 2021. Hope this is clear. Next, that is resignation of director and effective date of resignation. Moving to removal of director. There are two situations in which director can be removed. First of all, director is appointed by whom? By shareholders. Thereby, the power to remove directors is also available with shareholders. How the shareholders will remove? How the shareholders have appointed? They have appointed by general meeting ordinary resolution. Thereby, removal also can be made by general meeting ordinary resolution. Hope that is clear. That is the first case where shareholders will remove the directors. Second case, by order of tribunal on application made under section 241. Okay, that is 241 application is oppression and mismanagement. Any of the shareholders any of the members of the company can make an application of oppression or mismanagement against the company to the tribunal. Once application is made to the tribunal, tribunal can under section 242 pass an order of removal of director. Okay. Now we'll see the procedure in case of director is removed by the shareholders. First of all, if shareholders want to remove a particular director, they have to give, along with the general meeting ordinary resolution, 14 days special notice under section 151 to the company. Okay, they have to forward a notice to the company. The notice must be special notice under section 115. What is the when can a notice can be called as special notice? See, for a notice to be known as special notice, it must be signed by members holding not less than 1% voting right or shares on which at least 5 lakh rupees has been paid up. If it is signed by this number of members, then that would be known as special notice. Such a special notice must be given by the shareholders to the company for removing a director. Exception. Now, the shareholders cannot remove these two types of directors. Who are they? First one is director appointed by the tribunal under section 242. Okay, when an application for oppression or mismanagement is made to the tribunal as a order against such application of oppression and mismanagement under section 242, there are various types of orders that the tribunal can pass. One of the order that the company can pass under section 242 is to replace the existing directors with a new directors. Now, if any of the directors are appointed by tribunal under section 242, then such directors cannot be removed by the shareholders. Hope that is clear. Next, directors who have been appointed by concept of proportional representation under section 163, that minimum of 2/3 of directors must be appointed through proportional representation. However, it is optional. Okay, if at all company opts to appoint directors in the company by this proportional representation method, even in that case also, such directors who have been appointed through this proportional representation cannot be removed by the shareholders. These are the two exceptions. And another important point is, see, an independent director, if shareholders want to remove an independent director who has been appointed for a second time, in that case general meeting special resolution is required. Normally, to remove a director, general meeting ordinary resolution is sufficient, but to remove an independent director who has been appointed for the second time, general meeting special resolution is required. Why general meeting special resolution is required? Because for appointing independent director for second time, general meeting special resolution is required. Okay, for appointing also special resolution required. That is the reason why for removal also special resolution required. Hope that is clear. Okay, for removing independent director who has been appointed for the second time, general meeting special resolution is required. That is the concept of section number 169, removal of directors. Now, final topic of independent directors. We have covered almost all the topics except the powers of board of directors. We have covered not powers of board of directors, duties of directors. Except duties of directors, we have covered all the sections of first chapter. Okay, the duties of director, there are some 6 to 7 duties that you can that are easily understandable, that I am not going to cover, and we are left with the concept of independent directors. In this chapter we will see that independent directors concept. Section number 149, subsection 4 to subsection 12. Yeah, first of all we will see the applicability of this concept of independent directors. To which companies this independent directors concept is applicable? First of all the listed companies. Okay, all the listed companies must appoint at least 1/3 of its total directors as independent directors. Okay, of total directors of listed company, at least 1/3 must be independent directors. Okay, that is regarding listed companies. And other public companies, okay, other unlisted public companies who are having paid up share capital of 10 crores or more, or turnover of 100 crores or more, or outstanding loans, debentures, deposits of 50 crores or more. In that case, these companies must appoint at least 2 independent directors. Okay, listed companies must appoint 1/3 of total directors as independent director. Unlisted public companies who are following into this criteria must appoint at least 2 independent directors. Now, if you remember this criteria here for the independent directors, the same criteria of paid up share capital 10 crore more, turnover of 100 crore more, or outstanding loan, debentures, deposits of 50 crores or more is applicable even for audit committee and nomination and remuneration committee as well. Okay, now these are the 2 types of companies for which independent directors concept will be applicable. That means for private companies, independent directors is not applicable, and there is a exemption for unlisted public companies. Here you have to concentrate. For some types of unlisted public companies, the concept of independent director is not applicable even if they fall into these criteria. What are they? These 3: joint venture company, wholly owned subsidiary company, dormant company under section 455. If these 3 companies are unlisted public companies and falling into this criteria, okay, even though they are falling into this criteria, the concept of independent directors will not be applicable. But if these companies are listed companies, then the concept of independent directors will be applicable. Hope that is clear. Next, that is the applicability of independent director section. Now, eligibility of a person to be appointed as independent director. Okay, if you want to appoint a particular person as an independent director, what are the eligibility requirements of such person? The first eligibility requirement is he should not be managing director, whole time director, nominee director. Okay, that means he should not be executive director and he should not be nominee director. Okay, this is the first requirement. Next, the second requirement is he should possess relevant expertise and integrity. Okay, and the third requirement is the person who is or was not promoter of company or company's holding company or company's subsidiary company or company's associate company. Okay, the person whom you are going to appoint as an independent director must not be, okay, is or was, he is not, or in the past also he has not acted as promoter of the company or its holding company or its subsidiary company or its associate company, or and he should also be not related to promoter or director of company, holding company, subsidiary company, associate company. Okay, this is the third qualification that has to be possessed by the person whom you are going to appoint as an independent director. Fourth qualification: person should not have or had any pecuniary relationship. That is, pecuniary relationship means transaction in money or transaction exceeding 10% of his total income with whom? With company, with holding company, with associate company and with subsidiary company, and also with promoter director of company, with promoter director of holding company, with promoter director of associate company, with promoter director of subsidiary company. Okay, now for how many years you have to check this qualification? For current financial year and also for preceding 2 financial years. Okay, he should not have any pecuniary relationship for current financial year and also for preceding 2 financial years with these people. Hope that is clear. Here company means the company in which you are proposing this person as an independent director. Hope that is clear. Next, there is a note. Now, following transactions will not be included in pecuniary relationship. What are they? Remuneration. Okay, remuneration, receiving of a remuneration from the company will not be treated as having pecuniary relationship with the company. Okay, or receiving reimbursement of board meeting expenses. Director must have attended the board meeting. Now, for attending the board meeting, some expenses might be incurred by the director. Now, the company will reimburse such board meeting expenses to the director. Such reimbursement of board meeting expenses will not be treated as a pecuniary relationship. And profit related commission, if the company is giving any profit related commission to the director, even in that case also such a transaction will not be treated as pecuniary transaction. These are the exceptions for pecuniary transactions. That is the fourth qualification that an independent director must possess. Next, fifth qualification. Yeah, relatives of person or not. See, this fifth qualification has to be checked on the relatives of the person whom you are going to propose as an independent director. What are those qualifications? See, the relatives of person are not holding any security or interest in the company, in the company's holding company, in the company's subsidiary company, in the company's associate company. Okay, there is a exception to this, wherein in the exception the relative can hold security in the above companies of fair value not exceeding 50 lakh or 2% of paid up share capital of such particular company. That is the exception. Okay, next, relative of person are not indebted to the company, holding company, subsidiary company, associate company, and also to promoters, directors of such a company, holding company, subsidiary company, associate company. Okay, now exception, the exception is they can be indebted to the company up to 50 lakh. Okay, up to 50 lakh is allowed. Next, the relative should not give guarantee on behalf of third party to company, holding company, subsidiary company, associate company, directors or promoters of such companies. The exception is guarantee can be given up to 50 lakhs. Now, the fourth one is the relatives of such a person should not have any pecuniary transactions with company, subsidiary company, associate company, holding company amounting to 2% or more of its turnover together with A, B and C. See, A, B and C means together with these three transactions, A, B, C. For calculating this fourth qualification, while calculating this 2%, you have to include the transactions of A, B and C. Okay, of this holding of security, indebtedness and guarantee should also be included while calculating 2% of the turnover for this fourth disqualification. Okay, what happened? Okay, together with A, B and C, because he said pecuniary transaction. Even these three transactions are also pecuniary transactions only because they are involving money. Okay, now for how many years you have to check this qualification? For current year and 2 preceding financial years. Okay, these 4 qualifications has to be checked for current year and also for preceding 2 financial years. Hope that is clear. Next, last qualification. This has to be checked for both, neither he nor his relatives. That means neither the person whom you are going to appoint as an independent director nor his relatives holds or held any position of key managerial personnel or employee of company, holding company, subsidiary company, associate company. Key managerial personnel means managing director, whole-time director, CEO, CFO, CS. These people will be known as, and also manager. Okay, these 6 people will be known as key managerial personnel. The person whom you are going to appoint as independent director or the relative of such a person whom you proposed should not have held or being, or holding any position of key managerial personnel or acting as employee of the company, holding company, subsidiary company and associate company. The exception is relative can act as employee of such companies. Okay, for relative and that too for employee, for being acting as employee, there is exception. One second. Yeah. Okay. Next. Neither he nor his relative is or was employee, proprietor, partner of firm of auditors, company secretaries, cost auditors, or legal firm having transaction of 10% or more of such firm's turnover of company, holding, subsidiary, associate. See, this company, holding company, subsidiary company, associate company will be having some auditors appointed now. They will be having some cost auditors appointed now. They will be having some company secretaries appointed now. Now, the person whom you are going to propose as independent director or his relative must not be employee, proprietor or partner of such 3 firms. Hope that is clear. Next, this company might also be having a legal consultancy firm now. Okay, the company might be entering into some transaction with the legal firm now. Now, you should not be employee, proprietor, partner of such a legal consulting firm which is having a turnover of 10% or more of such firm's turnover. Okay, hope that is clear. Next, now these 2 has to be checked for preceding 3 financial years. Hope that is clear. These 2 qualifications has to be checked for preceding 3 financial years and balance remaining 2. Neither he nor his relative holds 2% or more of voting power of company. Okay, here holding a subsidiary, associate is not covered, only company. Next, the person whom you are proposing or relative is not chief executive or director of any non-profit organization receiving 25% of its receipts from company, promoter, director, holding company, subsidiary company, associate company. Okay, there is a particular non-profit organization. That non-profit organization is receiving 25% of its receipts from the company, promoter, director, holding company, subsidiary company, associate company of this company. And for such non-profit company, for such non-profit organization, there is one chief executive or there is one director. Now, such a chief executive, such a director cannot be appointed as independent director of this company. Hope that is clear. Or is a chief executive or director that holds 2% or more voting power of company. Okay, these are the qualifications that the independent director must possess. Next, declaration by independent director that he meets all the above criteria. He has to declare in 3 situations. What are those 3 situations? First of all, at the first board meeting in which he participates as a director. Okay, he has been appointed as an independent director of the company. After appointing as independent director of the company, he will be participating as a director in the first board meeting. Now, in such a first board meeting, he has to give declaration that he is complying with all the requirements that have been specified under section 149 subsection 6. Okay, that is the first area where the declaration has to be given. Next, at the first board meeting of every financial year. Okay, in the every financial year there will be some first board meeting. Now, at such a first board meeting also, this independent director must give a declaration that he is qualifying all the qualifications that are prescribed under section 149. Next, if there is any change in the circumstances that affects his status as an independent director. Okay, if at all there is any change in the circumstances and due to such a change in the circumstances, his status of independent directors, his status of being qualifying the above qualifications is disturbed. Even in that case also, he has to give declaration to the company. These are the three cases in which declaration has to be given. Remuneration of independent director. First of all, you cannot give stock options to the independent director. That is the first point. Okay, stock options cannot be given to the independent director. Next, however, you can give sitting fees to the independent director. You can reimburse the board meeting expenses to the independent director. Okay, for attending the board meeting, the independent director must have incurred some expenses. Now those expenses can be reimbursed by you, and also you can give profit related commission to the independent director. Hope that is clear. You cannot give stock options, but you can give sitting fee, reimbursement of board meeting expenses, and profit related commission. Tenure. This tenure is very important. See, the independent director can be appointed for 5 consecutive years of 2 terms. 1 term is equal to 5 years. Like this, he can be appointed for 2 terms. That means for a total of 10 years. Okay. For the first term, general meeting ordinary resolution is sufficient. But for appointing for second term, general meeting special resolution is required. Okay. Now, see, there is particular point regarding this. I'll tell you. Yeah. See. First of all, independent director, one second. Independent director can be appointed for 2 terms. Okay. 1 term is 5 years. Okay. This is the general rule. Now let's say a particular company has appointed independent director for a period of 3 years. Okay. 3 years has been completed. After completing 3 years, again it has reappointed him for another 5 years. Okay. This 5 years also completed. Now again the company wants to reappoint him for another 2 years, because the total is 10 years now. 2 terms into 5 years, which would be 10 years. Therefore the company wants to appoint him again for another 2 years. Whether it would be possible or not? The answer is, it is not possible. Okay. You have appointed him for term 1. Okay. Even though you have appointed him for a period less than 5 years, it will be treated as completion of 1 term. Okay. And you have appointed him for term 2. What the general rule says? General rule says that independent director can be appointed for maximum of 2 terms. You have appointed for 2 terms. It is secondary that 1 term will be maximum of 5 years. You can appoint director even for less than 5 years also, but such less than 5 years would be treated as completion of 1 term. Hope that is clear. Hope you understood this. Next. And the independent directors will be selected from data bank. Okay. A particular organization that is notified by the government will maintain a data bank of independent directors, and the companies will select the independent directors from that database. Okay. Next we are left with some provisions relating to director identification number. Those are very simple provisions. Section number 153 to 159 will be dealt by DIN. See, first of all, in case of company, they will be having director identification number, and in case of LLPs, limited liability partnership firms, the partners will be having DPINs, that is designated partner identification number. Now DIN and DPIN are same. Okay. If you are having the DIN, it means that you are also having a DPIN. The same number will be known as DPIN also. If you are having a DPIN, it means that you are having a DIN. Okay. Basically, both DIN and DPIN are same numbers. That is the first point. Next, one person can have only one din. Okay, a person cannot hold more than one din. That is the second point. Application for din. How can a person apply for a din? There are two routes. First of all, you want to get appointed as director of existing company, or you want to get appointed as a director of a new company. Okay, if you want to get appointed as director of existing company, then you have to file form DIR 3 with the MCA, and the MCA will allot you the din. Or if you want to be appointed as director of a new company which is being incorporated now, in that case, for incorporating the company, you will be filing Spice Plus, that is INC 32. Previously it was there, now it is Spice Plus. In this Spice Plus form, the din will be automatically allotted to the directors. Okay, to maximum of 3 directors, the din will be allotted in this Spice form. Okay, those are the 2 ways in which din can be acquired. Now once the application is made, if at all there are any defects in the application, the MCA will request the person to rectify the defects. Such defects must be rectified within a period of 15 days. Okay, now after rectification, the central government shall within 1 month give the director identification number. Okay, now on receipt of director identification number by director, the director shall intimate this director identification number to the company. Within how many days he has to intimate? He has to intimate within 30 days in form DIR 3B. Okay, once it is intimated to the company, company shall intimate this director identification number to ROC. Within how many days? Within 15 days, 15, in form DIR 3C. Okay, now every director has to file a form known as DIR 3 KYC every year to keep his din in an active position. Okay, those are the important points relating to din. Next, section number 170, which deals with register of directors and key managerial personnel and shareholding. This concept of key managerial personnel will be reading in we will be discussing in appointment and remuneration of managerial personnel. Basically, KMP means manager, managing director, whole-time director, CS, CFO, CEO. Okay, now the register has to be maintained by the company, wherein all the details relating to this directors, KMP and shareholding, their shareholding must be given. Now in this register there are various requirements like their name, their nationality, their address, their mobile number, their contact details. All these details has to be maintained in the register, and this register will be, see, members can inspect these register during business hours and request for photocopies of these registers. Okay, once members request for the photocopies, those photocopies must be provided by the company within 30 days, and that too free of cost. Okay, now if company refused to provide photocopies or refused to give access of these register to the shareholders, then shareholders can make an application to the ROC, and ROC will pass an order asking the company to allow these shareholders to access the registers. Hope that is clear. Now these registers must be kept open for inspection at every annual general meeting also. Okay, this is the concept relating to register of directors. By this we have completed revision of our first chapter, that is appointment and qualification of directors. In the next video we will meet with revision of appointment and remuneration of managerial personnel. Hope that is clear.